Gentlemen, you're all welcome to today's proceedings, which is simply for us to take the two judgments that we have listed. Registrar, can you call the first case?
Yes, my lord. Appeal number CA/MK/30/2013 between Alhaji Muaz Shaka and Dogara Garuba, Ibrahim Garuba, Rabo Garuba, Damina Garuba. Allowed parties absent.
Appearances, please.
So, with due respect, my lord, Dr. Enjuma Shigawa with Amanambu Isaac for the appellant.
Dr. who?
DG Shigawa, my lord. DG Shigawa with Amanambu Isaac for the appellant.
Which one is the surname? Is it Isaac or Amanambu?
Okay, Isaac, right? Surname. Amanambu is so the surname.
So the first name should be Isaac.
Yes, the first name is Isaac Amanambu. Yes, my lord.
Yes.
We are appearing for the appellant. Thank you.
Yes. Who is there for the respondent?
With greatest compliment to my lord, Emeka Okoye appears for the respondent cross appellant. Emeka Okoye for respondents cross appellants. All the respondents are cross appellants.
So Dr. Shigaba, you are for the appellant cross respondent. Dr.
Yes, my lord. Okay. Yes, my lord.
The judgment.
As my lord pleases.
This appeal emanated from the judgment of the High Court of Nasarawa State, sitting in Apanga, hereinafter to be known either as the lower or trial court, for Honorable Justice John A.V. Kuje in suit number NSD K9 2004, delivered 9th December 2011. The plaintiff at the lower court, who before us is the appellant, had sought the following reliefs against the defendants who are the respondents herein. And the reliefs are: one, a declaration that the land located and situate at Gunduma, by the left-hand side along Old Kefi Kaduna Road, Gunduma, is the farmland of the plaintiff. Two, an order of court directing the defendants jointly and severally to vacate the farmland by making same free for the plaintiff's use and enjoyment. Three, a perpetual injunction restraining the defendants jointly and severally, as well as their agents, servants, etc., from any further acts of trespass and or interference with the farmland in whatever purpose howsoever. And four, cost of this action. Defendants filed a joint statement of defense and counterclaim, wherein they counterclaimed as follows against the plaintiff. A declaration that the defendants are bona fide owners of the land, lying and situate opposite Angwang Kwara, near Gunduma, Kashi Development Area. A declaration that the purported document obtained from Kefi local government or any authority or agency relating to the defendant's land be declared null and void as having been obtained by fraud. C, a perpetual injunction restraining the plaintiff, his agents, etc., from continuing further acts of trespass on the defendant's land. And D, the cost of this claim. After hearing evidence of the parties, the learned trial judge in his considered judgment struck out the action on the ground that the plaintiff, rather than join the Gunduma family in bringing the action, brought same on his own behalf alone. Disturbed by the judgment, the plaintiff, who is now appellant, filed a notice of appeal, which notice was subsequently amended pursuant to the leave of court obtained 2nd February 2016. The respondents filed a notice of cross appeal on 9th May 2013. The main record of appeal was compiled and transmitted out of time to this court on 28th January 2013, but was deemed properly transmitted on 25th September 2014. The supplementary record of appeal was also compiled and transmitted out of time on 30th June 2014, but later deemed properly transmitted on 4th May 2016. In line with the rules and practice of this court, the parties filed and exchanged briefs of argument. Appellant's brief, filed out of time on 1st December 2014, was deemed properly filed 2nd February 2016, and the appellant's reply brief, also filed out of time on 5th May 2020, was deemed properly filed on 9th March 2021. Both briefs were settled by Dr. D.J. Shigaba. The respondents filed a respondent's cross-appellant's brief of argument out of time on 23rd April 2018, but it was subsequently deemed properly filed on 17th March 2020. And the said brief was settled by A.O. Maduabuchi Esquire. At the hearing of the appeal, the learned senior counsel, Oba Maduabuchi SAN, applied to withdraw the preliminary objection incorporated and argued at pages 2 to 9 of their brief of argument. The preliminary objection thus withdrawn from the respondent cross-appellant brief of argument is struck out.
As the court pleases.
Furthermore, upon being invited by the court to further address it on the location/boundaries and identity of the land in dispute, the learned counsel for the appellant, Dr. D.D. Shigaba, complied by filing and serving their further address, dated and filed 12th July 2021. Learned counsel for the respondents, Emeka Okoye Esquire, on his own part, complied by filing and serving their own submission dated 10th July 2021, but filed 12th July 2021. By the way, we can just pause at this point, let Emeka Okoye Esquire take note of the fact that my surname was wrongly spelled, contrary to what I wrote or what was in my memo. It was wrongly spelled by Emeka Okoye. Please take note and try not to repeat that mistake again. Thank you.
As the court pleases.
Now, from the 5 grounds of the amended notice of appeal, the appellant posited the following 4 issues for determination in this appeal. And the issues read: 1, whether the learned trial judge was wrong not to have awarded title to the land in dispute to the plaintiff in view of the overwhelming evidence in his favor. And this issue stems from grounds 1 and 2. 2, whether the learned trial judge was wrong to have unilaterally set aside the gift of the land in dispute when it was not an issue in the defendant's case. Ground 3. 3, whether the learned trial judge was wrong to have struck out the case of the plaintiff in the circumstances, and if the answer to the above is in the affirmative, whether it is not a case that deserves an order for retrial in the event this court finds that title has not been proved by the plaintiff. You didn't state the ground from which this issue emanated. Ground 4, issue 4, whether the learned trial judge did not properly conduct the visit to locus inquo, thus occasioning a miscarriage of justice to the appellants. Also, the ground from which this issue originated is not stated. Now, the respondents adopted and argued the issues as set out above. So, issue 1 should read again whether the learned trial judge was wrong not to have awarded title to the land in dispute to the plaintiff in view of the overwhelming evidence in his favor. And with your permission, may I skip your submissions there and go straight to the resolution? Incidentally, issues 1 and 3 were merged and argued together. So they're in resolving issues 1 and 3 merged together, I have this to say. A plaintiff appellant had pleaded inter alia at paragraph 37 of their statement of claim for a declaration that the land situated at Gunduma by the left-hand side along Kefi Kaduna Road is the plaintiff's farmland. The plaintiff appellant, as the PW1, had in his evidence identified the following as the boundary neighbors of the land in dispute, and they are: to the east, the old Kefi Kaduna Road; west, a running stream; north, stream running around; and south, small settlement called Lagos. PW2 merely testified that the land in dispute is in Gunduma along Old Kefi Kaduna Road. However, the PW3 Bako Bala went further to testify as regards the boundary neighbors of the land, to which east, Motor Road, north extends to the bridge, south, bounded by stream called Ratfink Dia, and west, Unduma. Notwithstanding the discrepancy which we observe in the foregoing evidence of PW1 and PW3 regarding the boundary neighbors, particularly at the southern end of the land in dispute, it still does not rub off the fact that the identity of the land as claimed by the appellant is not lost to the parties. This is more so as the identity of the land was never made an issue at the lower court. Neither does it arise from any of the grounds of appeal in this court. The respective parties' evidence in respect of the parcel of land in dispute is clearly ascertainable by them. I think, therefore, that the respondents are raising the issue of identity before this court merely as an afterthought. There is nothing on record to suggest that the parties are unsure of the land in dispute. There is thus no room in the circumstances for the respondents to call for a dismissal of this appeal on the ground that the land claimed by the appellant is not identifiable. As I noted above, the discrepancy regarding the identity of the land is not enough for this court to rule that the said land is not known to the parties and so dismiss the appeal as is being urged by the respondents. And I'm having recourse to some authorities which I have enumerated and which you can read up later. But I wish to point at the authority of Adamu and Esonanjo, citation supplied by Abiru JCA, where he said, and I quote, "To be substantial and fundamental, contradictions and sometimes mix-ups in the evidence of a party's witnesses must amount to a disparagement of other pieces of evidence adduced. Contradictions that do not materially affect the fundamental and crucial issues joined by the parties in the case, and which do not go to the substance of the matter, are not necessarily fatal. And what is material and substantial remains a question of fact in every case," unquote. I also touched on the case of Atamwale and Odusonmi, citation supplied, where the Reverend Rotsviver JSC, as he then was, enjoined that in a claim for declaration of title to land, the starting point is the identity of the land. The identity of the land must be clearly ascertained. The identity of land would be an issue if and only if the defendant in his pleadings disputed either the area of the land or its location, unquote. According to the appellant as pleaded in paragraphs 3 and 4 of his statement of claim, 3, the land, the subject of dispute, is situate and located at Gunduma village by the left-hand side of Old Kefi Kaduna Road. 4, that originally the area was established and founded by the plaintiff's great-grandfather named Sarikin Kefi Abdullahi Maje Gunduma, unquote. In a similar tone, the respondents also at paragraphs 3 and 4 of their proposed statement of defense of first, second, third, and fourth defendants averred as follows. 3, that the land, the subject matter of dispute, is located at Angwan Kwara village near Gunduma, by left-hand side of the Kefi Kaduna Road. 4, the defendants deny paragraphs 4 and 5 of the claim and aver that their forebears founded the land by deforesting same, built and farmed on part with members of their family, including the defendants, unchallenged for decades until recently, when plaintiff began his false claim, unquote. Reading through the foregoing pleadings, it does not seem to me that the identity of the land in dispute is shrouded from the parties. While both parties aver that the land is located on the left-hand side of Kefi Kaduna Road, the only disparity is that while the plaintiff claimed that it situates in Gunduma, the defendants on their part claim that the land is situated at Angwankwara village near Gunduma. Notwithstanding the inconsequential disparity regarding the land in dispute, we are satisfied that the parties know the land in question. The location and area of the land is substantially determinate, more so as the parties, together with the trial court, went on a visit of the local court and saw things themselves. Now, in order to establish ownership or title to land, the law has crafted the following 5 modes. A, proof by traditional evidence. B, proof of acts of ownership, acts of persons claiming the land, such as selling, leasing, renting out all or part of the land, or farming on it, or otherwise utilizing the land beneficially. C, acts of ownership extending over a long period of time and numerous and positive enough to warrant the inference that he is the true owner. D, proof by production of document of title, which must be authenticated. And E, proof of ownership by acts of long possession and enjoyment in respect of the land to which the acts are done, as well as proof of possession of connected or adjacent land in circumstances rendering it probable that the owner of such connected or adjacent land would in addition be the owner of the land in dispute. And you see some authorities, which includes Takolo and Riwani Takolo, as well as the popular Ijun Kumagba, with their citations all supplied. As to how he came by the land in dispute, the appellant pleaded in paragraphs 11 to 14 of his statement of claim to the effect that the land, which was a family land, was an outright gift to him by members of the family when he expressed desire to go into farming. The land came to him as a result of his being a male descendant of Abdullahi and through his father Isha. A document evidencing the gifting, which was originally in Hausa language, was subsequently translated into English language and admitted in court as Exhibits 1 and 2, respectively. The appellant testified in line with his pleadings that he inherited the land from his father, and his father in turn inherited same from his own father. He also testified that Maje Gunduma, his forefather, founded and deforested the land. Other people came later to join Maje Gunduma on the land. The PW 1 and 3 on their side gave evidence that the land was founded by their ancestor, Abdullahi Maje Gunduma, and that the appellant was one of his heirs who subsequently inherited the land. They testified that the appellant inherited through his father, Isha, and that the whole family consented and made a grant of the same to the plaintiff appellant. In spite of the clear evidence before the trial court, it remained unclear how the learned trial judge came to hold as follows, and I quote the learned trial judge. It is my opinion that even when the story of the title to this land as narrated by the evidence of the family members sounds probable, their action in assigning this land to another person without having recovered the land from the defendant's family, which they said it was their family who gave them, is not legal and amounts to trespass. A person in possession can complain of trespass, unquote. Now, it seems to me from the foregoing that the lower court had judged it more probable that the title to the land vests on the Maje Gunduma family. For the said court to turn around in the same breath and see the members of the Maje Gunduma family as trespassers on the same land is a bit unsettling. The evidence before the court is that part of the land was let out on loan by the plaintiff's uncle, to the father of the defendants, that's defendant's respondents. A piece or parcel of land on loan does not constitute an outright gift to the grantee. This is to say that though possession of the land may have been transferred to the grantee, ownership of the land per se remained on the grantor, consequent upon which the grantor cannot be adjudged a trespasser on his own land. In this vein, the heirs and or descendants of Alhaji Maje Gunduma, amongst whom is the appellant, would not need to formally recover any portion of their said land which they gave out on loan to the respondents before such portion can be allotted or assigned to the appellant. This is not to say that the person in possession cannot complain of trespass. He can complain against any other person, but not against his overlord, who in the instant case is the appellant. You see the case of Sunday Ufomba and Wosu Akuchogo, where my Lord Ogundere JSC, as he then was, held that trespass is a violation of possessory rights and does not involve title to land. The Maje Gunduma family cannot be found to have violated the defendant's possession, since what they did was to assign their land in the possession of the defendant's respondents to the appellant as a gift. Although it is desirable to formally recover the land on loan before allocating same to any member of the overlord's family, that, however, is not the position under customary tenancy. So, having taken cognizance of the fact that the respondents were customary tenants of the appellant, it became unnecessary for the learned trial judge to go on the spree of discovery, as evident in the barrage of questions posited by him in his judgment to make a case for the defendants outside what was before the trial court. I said that I feel the need to reproduce some of the questions posited by the learned trial judge. And I enumerated the questions, but you can read that too. Now, the plaintiff appellant, as a descendant of Maje Gunduma, founder of the land in issue, was erroneously referred to as another person in an issue pertaining to the land in dispute. The learned trial judge obviously went off tangent, positing all the questions as set out above. By those questions, the learned trial judge by implication was aiding the defendant's respondents to deny the overlordship of the appellant over the land in dispute.
Let's go, please.
Nevertheless, the appellant was able to prove by traditional evidence that the land in question was founded and deforested by his forebear, Abdullahi Maje Gunduma, that Maje Gunduma's heirs, among whom was the appellant's grandfather, inherited the land from him. Then the appellant, through his father, stepped in, and with the consent of the whole family, of which PW2 and PW3 were members, the land was given to him as a gift in 1983. The gifted land included the portion that was earlier let on loan to the respondents by the appellant's uncle. To further fortify his ownership of the land, the appellant applied for and was issued with certificate of occupancy number PL 16242, which was admitted in evidence by the court as Exhibit 2. Exhibit 2 on its own is a prima facie evidence of ownership of the land in dispute. You see the case of Grace Madu and Dr. Bertram Madu, citation supplied. There is nothing on record to show that the respondents in both their pleadings and evidence impugned the presumption accorded by law on the appellant's certificate of occupancy, that is Exhibit 2. The appellant also proved ownership by positive acts of possession extending over a long period of time. It is in evidence of the appellant that the descendants of Maje Gunduma owns the whole area of Gunduma, save for the portions he sold out or gave as gifts to settlers. It is in their uncontroverted evidence that the army barracks was acquired from the Gunduma descents and compensation paid to them. This shows that the family of Maje Gunduma, of which the appellants belong to, have exercised acts of ownership over adjacent lands spanning over a long period of time. Being the owners of the land, no tenant's possessory right, including that of the defendant's respondents, can override the ownership right of the Maje Gunduma descents. Indeed, the learned trial judge, with the overwhelming evidence of ownership in favor of the appellant, ought to have awarded title to the appellant as claimed by him. Issue 1 is thus resolved in favor of the appellant. Furthermore, the question whether the learned trial judge was wrong to have struck out the case of the plaintiff in the circumstances is answered in the affirmative. Not in the face of the cogent and positive evidence in favor of the appellant regarding his entitlement to the land in dispute. Be that as it may, we do not see the instant action as one that calls for a transmission of the case file back to the lower court for retrial. This is because this court is seized of the power pursuant to Section 15 of the Court of Appeal Act 2004 to step into the shoes of the trial court and address the nagging issues which were either left unresolved or wrongly resolved by the said lower court. Aside from the extra cost, both in time and resources, such a retrial will bring to bear on the parties, the appellant hearing will suffer a miscarriage of justice where a retrial is ordered in the circumstances. We have, in the exercise of the provisions of Section 15 of the Court of Appeal Act 2004, evaluated the evidence of the parties, both oral and documentary, in order to arrive at the just conclusion of the matter. And we support this with some cited cases. Section 15 supra, in its latitude, enables the appellate court to exercise all the power so far Court of First Instance can exercise. Instead of sending the case file back to the trial court for a retrial, Section 15, in an appropriate case such as this, empowers this court to assume the jurisdiction of the trial court and determine the real question in controversy between the parties, so as to save the much needed time in the administration of justice. The question here is whether the instant case deserves an order for retrial. And the clear answer is no, it does not deserve such an order. This court has taken time to reevaluate the evidence adduced herein by both sides and is satisfied that the appellant has successfully proved his title over the disputed land. It is on this premise that issues 1 and 3 are resolved in favor of the appellant and against the respondents.
As the court pleases.
Please.
Issue 2, whether the learned trial judge was wrong to have unilaterally set aside the gift of the land in dispute when it was not an issue in the defendant's case. Again, taking cognizance of your submission, we have this as a resolution of issue 2.
As court pleases.
That contrary to the submissions of the learned counsel for the appellant, the issue of the gifting of the land in dispute to the appellant was made a life issue between the parties. The respondents clearly at paragraph 10 of what seems to be their statement of defense had averred as follows, and I quote, "The defendants aver that if there was any grant to the plaintiff by his alleged family, such a purported grant was not in respect of the defendant's land." DW1 in his testimony in court stated inter alia that the plaintiff has no land at the place in dispute. The DW2 on his part testified under cross-examination that the plaintiff has many pieces of land at the place in dispute. The DW3 testified thus, and inter alia, the plaintiff has never farmed there. The plaintiff has never farmed on the land. The plaintiff bought his land from Salao about 20 years ago. The plaintiff had no land there from the beginning. Yes, he, we knew, has bought pieces of land around the area. He shares boundary with us now. The plaintiff is claiming the land is also his own. And then DW4 on his part said, "I do not know the plaintiff," unquote. Now, I had to pick out the foregoing bits and pieces of evidence of the defense witnesses to show that the defendants pleaded and canvassed the issue bordering on the gifting of the land to the plaintiff appellant by his family members. This claim of grant was evidently challenged by the respondents. It was therefore an issue before the lower court, and that being the case, the learned trial judge was duty-bound to reach a decision one way or the other, like he did, to wit, and I quote him again, "This court is therefore of the view that the unilateral gift of this land to Mazu Ishak without first of all recovering possession of the land from the family of the defendants was wrong and unlawful. This court therefore hereby sets aside this gift of land, the Ishak, Muazu, and the exhibit evidencing the gift is hereby set aside. The land is still in the possession of the defendants, either as people who were loaned the land by Maje Gunduma family or as the land their father Garba started, unquote. Now, I have recourse to the case of Icono LG versus Beacon Finance and Security Limited, citation supplied, where this court, per Open JCA, had this to say, and I quote us, I entirely agree with the learned counsel for the appellant that the learned trial judge did not consider and make any finding of fact on prayer 3, and that where a trial court had arrived at a decision without considering an essential issue between the parties, that the decision cannot be allowed to stand, unquote. Now, the learned trial judge in the instant scenario found as a matter of fact that a portion of the land in dispute was still in the possession of the respondents. Nevertheless, it was erroneous of him to have on that ground ordered a setting aside of the gift of the said portion already made by the family of the appellant to the said appellant. I am saying that the gift ought to stand irrespective of the fact that the respondents were still in possession of it. This goes to answer in the affirmative the question whether the learned trial judge was wrong to have set aside the gift of the land in dispute. The decision, though erroneous, yet it obviously was not reached unilaterally as is being suggested by the appellant. It stems from paragraph 12 of the respondent's supposed statement of defense. However, the setting aside of the gift of the land in dispute by the Maje Gunduma family to the appellant was indeed a wrong decision. It is in this light that I shall resolve issue 2 in favor of the appellant and against the respondents.
As a court, please.
Issue 4. Whether the learned trial judge did not properly conduct the visit to locus in quo, thus occasioning a miscarriage of justice to the appellants. Again, I went on to resolve the issue, taking cognizance of your submissions, by saying that I need not waste much energy and time on this issue, given that the appellant failed to show how the visit to the locus in quo occasioned a miscarriage of justice to him, that he was not allowed the chance to go further at the locus to point out his neighbors at the southern end did not preclude his pleaded fact and evidence led in court to the effect that on the southern end of the land was a settlement known as and referred to as Small Lagos. The land thereat is bounded by the land of Ella Panza and Yakubu Tela. At page 83 of the record of appeal, wherein the proceedings at the locus in quo is cocooned, the learned trial judge had noted as follows. To skip his observation, you can read it up. The learned trial judge rightly decided to limit himself to the area issues have been joined by the parties. From the evidence laid before it, the trial court was satisfied that the parties had no issue regarding the identity of the land in dispute. Hence, the trial judge did not see the need to go beyond the point shown to him by the respondents as the limit of their land. The learned trial court contented itself with the boundaries necessary for the just determination of the issues before it. I am really at pains trying to make out what the appellant meant by that. The learned trial judge failed to consider the plaintiff's boundaries as stated in his pleadings, oral evidence, and documentary. The identity of the land in dispute at the expense of being repetitive is clear and certain to the parties. There is no justification for a call for retrial in the circumstances. Hence, the call is discountenanced.
As the court
The
pleases.
lower court properly conducted the visit to the locus impo. Issue 4 is hereby resolved in favor of the respondents and against the appellant.
As the court
At the
pleases.
end of the day,
Court pleases.
and with the resolution of issues 1, 2, and 3 in favor of the appellant and against the respondents, while issue 4 goes in favor of the respondents and against the appellant, it shows in sum that the appeal has succeeded only in part. That is to say that issues 1, 2, and 3 are in favor of appellant, while issue 4 goes in favor of the respondent. As it is, while the appellant was able to discharge the burden on him regarding his claim of ownership of the land in dispute, I am afraid that the respondents on their part failed to establish their counterclaim. The respondent's counterclaim is therefore dismissed for being unmeritorious.
As the court pleases.
For the avoidance of doubt, and as it were, it shall be the order and declaration of this court that A, the land located and situate at Bunduma, by the left-hand side along Old Kefi Kaduna Road, Gunduma, is the farmland of the plaintiff appellant.
As the court pleases.
B, the defendants are jointly and severally ordered to vacate the said farmland by making same free for the plaintiff's use and enjoyment. C, an order of perpetual injunction is made restraining the defendants jointly and severally, their agents, privies, servants, and or workmen from any further act of trespass and or interference with the said farmland in whatever purpose howsoever.
As the court pleases.
The appeal succeeds in part and the counterclaim is dismissed.
As the court pleases.
Costs assessed and fixed at 80,000 naira
As court
is
pleases.
awarded in favor of the appellant and against the respondents.
As the court pleases.
Now,
My lord, we are
now to the cross appeal.
okay.
There's a cross appeal here.
As the court pleases.
Cross appeal as filed and argued by the respondents, hereafter to be known as the cross appellants. The cross appeal is against the judgment of Nasarawa State High Court, wherein the court struck out the issue of title in suit number NSD K9 2004, based on the ground that the action was not instituted on behalf of the Maje Gunduma family. The learned trial judge further set aside the gift of the land made to the appellant. I stated in brief, the statement of facts leading to this cross appeal. You can read it, but at the end of the hearing and the filing and exchange of parties' final written address, the learned trial judge in a considered judgment delivered 9th December 2011 struck out the claim on grounds already set out above. The cross appellants felt disturbed by the fact that rather than dismiss the case of cross-respondent for having failed to prove his case, the lower court instead struck out the suit. And the cross appellants filed a notice of cross appeal on 9th May 2013. They also argued their cross appeal in their brief of argument, and the brief was settled by A.O. Maduabuchi Esquire. The cross-respondent replied to the cross-appeal in his reply brief, filed out of time, as I said, but subsequently deemed proper on 9th March 2021. And the said brief was settled by Dr. G.J. Shigaba. The cross-appellants crafted a sole issue for determination from the 4 grounds of the cross-appeal. And the issue reads whether the court was right to strike out the suit when the plaintiff failed to prove his case rather than dismiss same. The cross-respondents on their part adopted and argued the issue in their reply brief. Now, we took cognizance of the submissions, and the resolution of the cross appeal is that the learned trial judge, we started with the finding of the learned trial judge contained at page 105 of the record of appeal. This finding you should read on your own. I do not think that the finding of the lower court in any way calls for a cross appeal. That's the finding as set out above.
Let's go, please.
This is because the finding is not directed against the defendant's cross appellants. In the case of Chime and Onwebu Supra, duly cited by the learned counsel for the cross respondent, the apex court held, and I quote, "It follows, therefore, that whereas the respondent notice seeks to affirm the final decision of the court on the merit of the case on ground other than those stated in the judgment, the cross appeal is to set aside the ruling made in the judgment against the applicant on hope." The learned trial court, in his own wisdom and understanding, though erroneously, chose to strike out the case rather than dismiss same, having found, though wrongly also, that the plaintiff cross-respondent failed to prove his claim. Be that as it may, and as I already noted, there is no cause for the cross-appeal, given that this court has, pursuant to Section 15 of the Court of Appeal Act 2004, re-evaluated the evidence of the respective parties alongside their pleadings and came to the conclusion that the plaintiff cross-respondent was able to prove title over the land in dispute. To begin to x-ray the merit or otherwise of this cross-appeal will end up not serving any useful purpose to particularly the defendant's cross-appellants. It will not serve any probative value as it were. Given the authority of Lafia local government and executive governor Nasarawa State, whatever errors the defendant's cross-appellants may have perceived in the judgment of the lower court in the instant case has obviously been addressed in the main appeal. This cross-appeal is clearly an academic exercise, as it has no practical utilitarian value to the defendant's cross-appellants at this stage, more so as the main appeal has been concluded on its merit. This cross-appeal is obviously an academic exercise. I shall, in this vein, strike it out, and it is so struck out. So the parties in this cross-appeal are to bear their respective costs of pursuing the cross appeal. So this is the lead judgment hearing. My Lord Agube, JCA, the presiding justice in charge of this division, presided over the hearing of this appeal. He sent his contribution and it simply reads, I had the opportunity of reading the lead judgment just delivered by my learned brother, and I am in complete agreement with my Lord's reasoning and conclusion. That is as per my Lord Agube, the PJ. My other learned brother, who was also in the panel that had the appeal, sent in a contribution, and if I may be allowed to quickly go through it, it says, I had the privilege of reading in advance the judgment just delivered by my brother, and I am in complete agreement with his reasoning and conclusion in the lead judgment. The appeal is in two parts, the main appeal and a cross appeal. The facts of the appeal are clearly set out in the lead judgment, and I need not repeat them. My Lord, in very elaborate and exhaustive manner, dealt with issue of declaration of title raised in the main appeal, as held in Morgaji and Salami Adani, citation supplied. There is no room for any further elucidation. I therefore adopt the decision of my learned brother in the main appeal as mine, and also hold that the appeal succeeds in part and the counterclaim is dismissed. He went further to state that in considering the cross appeal, it is clear that the issues donated by the defendant's cross appellants had already been addressed in the main appeal. It is settled that defendant's cross appellants is stopped from presenting the same issues for determination that had already been determined in the main appeal. The courts have settled that there is estoppel against the cross appellant as it affects the issues and the parties. She went on to rely on the Apex Court's decision in Fadiora and Badebo citation supplied. The cross appellant, therefore, is stopped, and the issues presented are incompetent and hereby struck out. Flowing from above, I too find that the cross appeal is incompetent and must also be struck. So this is the judgment in this very appeal.
As the court pleases. My Lord, we are most grateful for this erudite judgment, my Lord.
Thank you.
I want to thank my Lord for all the pains she took in addressing this appeal, sir. We are most grateful, sir. Thank you.
Thank you very much. Can we now go over to the second judgment, which is a judgment in an appeal that we took at the Judicial Division. Thanks to virtual viewing, one can now deliver such judgment conveniently from this division. So can you please call up the second judgment?
Appeal number CA/J/247/2020. Between Leslie Integrated Investment and Engineer Ayuba Daniel Bank. Allowed parties absent.
Appearances, please. Appearances.
If it pleases my noble Lord, yes, my Lord, with respect to my noble Lord,
Yes.
announce appearance for the appellant. My name is Niri Darong. Appearing with me is my friend, my Lord, Intiang Jugu.
Can you help me with Intiang Jugu? Okay.
Jugu, my Lord, Intiang is Ntyang, my Lord.
Yes, I've seen the spelling.
Jugu, Jugu,
Okay.
my Lord.
You are for the appellant.
I'm very grateful, my Lord.
Yes, respondent. Respondent.
The respondent was up.
Thank you very much. Yes, my Lord.
Respondent. What day?
19th
I what means?
a true text message.
Direct to him.
Yes, my Lord. Oh, my Lord. The name,
Sorry?
the name here is LB Chop. S.E. Chop.
Through his counsel.
Who cancel, my Lord? Who cancel?
And the council's name is what?
S.T. initials. Chop.
T. S.T.
S.T. as development of God.
Okay, S.D.
Chop. Chop spelled J.O.K.
J.O.K. Okay. Thank you. Okay, the appeal metamorphosed from the judgment of the Plateau State High Court, hereinafter to be known as the trial or lower court, sitting in Jos, in suit number PLD J8ATM 2020, Quorum Honorable Justice S.J. Backford J. Delivered 30th June 2020. The plaintiff at the lower court, who before us is the appellant, by way of motion ex parte, filed 11th February 2020, sought for suit number PLD J80 2020 to be placed on the undefended list and for the writ of summons to be so marked. The plaintiff then claimed as follows against the defendants. 1, the total sum of 16 million naira being the total sum of the money paid to the defendant. 2, 10% interest per annum on the judgment sum from the date judgment is delivered until final liquidation. The motion was heard and granted as prayed. Upon service of the enrolled order and all other relevant processes on the defendant respondent, he filed a notice of intention to defend on 12th March 2020, wherein he urged on the trial court to transfer the suit to the general cause list for same to be determined on merit. The suit was, however, determined under the undefended list. In his said considered judgment, delivered 30th June 2020, the learned trial judge, rather than enter judgment for the plaintiff appellant as claimed by him, or on the other part, transferred the suit to the general cause list as urged by the defendant respondent, struck out the suit. Aggrieved by the judgment, the plaintiff appellant filed a notice of appeal in challenge of the judgment on 24th July 2020. The record of appeal was compiled and transmitted to this court within time on 9th October 2020. Parties in line with the practice and procedure of this court filed and exchanged briefs of argument. The appellant's brief, filed 6th November, was settled by N.I. Darong Esquire, while the respondent's brief, filed 9th December 2020, was settled by S.D. Jock Esquire. From the 6 grounds of the appeal, appellant crafted the following 3 issues for determination. 1, whether the trial court can raise an issue so motu and proceed to find and rule on it without hearing parties address it on same under the undefended list procedure. 2, whether if arguments have been taken in a suit under the undefended list, the trial court was not wrong to hold that it cannot transfer the suit to the general cause list. 3, whether the trial court was not wrong to have entered judgment for the appellant. The respondent adopted and argued the issues as formulated by the appellant. So issue 1, which is whether the trial court can raise an issue so motu and proceed to find and rule on it without hearing parties address it on same under the undefended list procedure, took cognizance of submissions and went on to resolve the issue as follows: that it is, first of all, an elementary knowledge of law that the court, not being Father Christmas, will not grant relief or reliefs not asked for. The appellant herein filed his ex parte application filed 11th February 2020, had sought for and was granted the leave of the trial court to have the suit placed on the undefended list. Upon service on him of the writ of summons and the enrolled order of the lower court placing the suit on the undefended list, the respondent filed a notice of intention to defend, and upon which he urged that the suit be transferred to the general cause list. Part of the findings of the lower court reads, and I quote, in the instance case, they're in dispute as to whether it's a debt or money owed the plaintiff or collected from the plaintiff by intimidation, unquote. Realizing that the affidavit in support of the defendant respondent's notice of intention to defend has thrown up triable issues such as is evident in the foregoing, the learned trial judge ought to have set the suit down for trial on the general cause list so that evidence could be led in proof thereof. Without hearing evidence of the parties, the learned trial judge erroneously went on to find as follows, and I quote the trial judge: in conclusion, the plaintiff has admitted in all his averments, which include his annexures, that there exist triable issues in this case. Accordingly, issues formulated by the appellant is resolved against him. On the other side, the defendant has made several averments and exhibited several documents of the dispute over contract to build 3 housing units who were partners in the business, and the court is clear that there was some form of partnership and the money involved relates to the partnership. And since the partnership was not in writing, evidence needs to be led to arrive at the facts of the partnership. A loan issue formulated by counsel to the defendant is resolved in favor of the defendant. For the avoidance of doubt, the claim of undefended cause against the defendant woefully fails. In consequence, this suit having been heard is not to be transferred to the ordinary course for determination. Rather, it is hereby struck out. Plaintiff may pursue his claim by filing a fresh action against the defendants by an ordinary process, unquote. By striking out the suit, as has played out in the foregoing, the learned trial judge, with all due respect, overshot the bounds of his jurisdiction and thus took a most far-reaching and preposterous decision. As rightly submitted by the learned counsel for the defendant respondent, upon finding that the affidavit in support of the defendant's notice of intention to defend disclosed a defense on the merit, the lower court ought to have invoked the provisions of Order 23, Rule 3, Sub 2 of the Plateau State High Court Civil Procedure Rules 1987, and thereby remove the suit from the undefended list and place same on the ordinary cost list. I set out the provision of this Order 23. Having not removed the suit from the undefended list, and then not placing same on the ordinary cost list for it to be determined on the merit, the learned trial judge breached the foregoing Order 23, Rule 3, Sub 2, Supra. His decision in the circumstances to strike out the suit is not governed by law and facts. And I supported this proposition with the case of Akingbola and the Federal Republic of Nigeria, citation supplied. It is a well-settled position of the law that there must be evidence before the court can proceed to make its finding on any issue submitted before it. See the case of Ezenwaka and Okon and others. While none of the parties in the instant case sought for a striking out of the suit, nor did they give evidence before the court to warrant the striking out of the matter, the court thereby did in chambers what the party failed to do by way of evidence in court. This proposition again is supported by a handful of authorities, which you will also read of when you pick up the judgment. The learned trial court, in the recesses of its chambers, called and conjectured and acted on facts not placed at its disposal, and finally came up with decisions unwarranted by the circumstances of the case. And leaning on the authorities I already cited, vis-a-vis the question whether the trial court can raise an issue so motu and proceed to find and rule on it without hearing parties address it on same under the undefended list, I dare answer same in the negative. And this is to say that the findings of the learned trial judge in this regard run counter not only to the impartial status expected of him, but also to the facts and reliefs sought of him. And the apex court did then join in the case of Jev and Iotion, citation supplied that by raising an issue so motu by a court, and basing a decision on it without argument from both parties, the party affected is denied the opportunity of being heard. And this is a breach of his right to fair hearing entrenched in Section 36 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Where court fails to bring an issue raised suo motu to the attention of the parties, an argument taken on it before deciding on it, such a decision is liable to be set aside. See Bori versus Agbi, and so on and so forth. That is the position of the law as regards raising issues suo motu. This is the apex court talking. The decision read thereto in the instant case, that is in the case before us, is thus set aside, same having been reached suo motu by the learned trial judge and without running same by the parties. Issue 1 is on this note resolved in favor of the appellant and against the respondent. Issues 2 and 3 were argued.
As the court pleases.
Yes, issues 2 and 3 were argued jointly, and I go straight to the resolution of the said issues 2 and 3. It is settled beyond peradventure that the purpose of the undefended list procedure is to ensure justice to the plaintiff where there is obviously no defense to his claim and prevent the injustice that delay or protracted litigation may occasion. This court, in the case of Dean and Okose, Nobu Sankey JCA, who while consenting to the leading judgment had this to say, and I quote her, under the undefended list, in the instant case as provided for under Order 23 of the High Court Civil Procedure Rules of Plateau State 1987 as amended, a defendant who intends to defend a suit filed against him is required to file a notice of intention to defend the suit, accompanied by an affidavit disclosing a defense on the merit. What this means is that the affidavit must not contain merely a general statement that a defendant has a good defense to the action. It must be supported by particulars which, if proved, would constitute a defense. It is sufficient if the affidavit discloses A, a triable issue, or that a difficult part of law is involved, B, that there is a dispute as to the facts which ought to be tried, C, that there is a real dispute as to the amount due, which requires the taking of an account to determine, or any other circumstances which show reasonable grounds of a bona fide defense, unquote. As I have noted above, having come to the realization that the affidavit in support of the defendant respondent's notice of intention to defend has thrown up triable issues, the learned trial judge ought to have removed the cause from the undefended list and set same down for trial on the general cause list, so that evidence could be led in proof thereof. On the contrary, and in a rather strange and misplaced manner, the learned trial judge struck out the claim of the appellant while still in the undefended list, and with a further order that the appellant should take out a fresh action, and for effect, the said order of the learned trial judge is reproduced hereunder. For effect, and it reads, for the avoidance of doubt, the claim of undefended cause against the defendant woefully fails. In consequence, this suit having been heard is not to be transferred to the ordinary cause list for determination. Rather, it is hereby struck out. Plaintiff, that is the appellant, may pursue his claim by filing a fresh action against the defendants by an ordinary process. Unquote. Looking at what has evolved in the instant appeal, I think that I am in agreement with the submission of the learned counsel for the appellant to the effect that the procedure adopted by the learned trial judge is strange and has no place whatsoever in law or established precedent. The lower court ought not to have entered judgment striking out the suit in the face of unresolved and triable issues thrown up by the affidavit in support of the defendant respondent's notice of intention to defend. If the trial court disbelieved the case of the appellant like he did in one breath, what he should have done was to transfer the case to the general cause list for full trial rather than terminate the suit. Cases initiated under the undefended list either end with entering judgment for the claimant as claimed, provided the learned court is satisfied that the defense of the defendant is without merit, or that the case is removed from the undefended list and placed in the general cause list for full-blown trial. The learned trial judge in the instant case muddled and mocked up the case when he neither found for the appellant's claim nor did he set the case down for hearing as prayed for by the respondent. It is on this premise that issues 2 and 3 are jointly resolved in favor of the appellant and against the respondent. Now, having resolved the formulated issues in favor of the appellant and against the respondent, it follows that the appeal is meritorious. Given the glimmer of triable issues disclosed in the affidavit in support of the defendant respondent's notice of intention to defend, I think and hold that the interest of justice shall be served better by transferring the case to the general cause list for parties to field witnesses in proof of their respective cases. A decision of the learned trial judges in this light set aside, it shall therefore be ordered, and it is so ordered, that the case file in suit number PLDJ80 2020 be transmitted back to the Chief Judge of the High Court of Plateau State, for reassignment to another judge for same to be set down in the general cause list for full hearing and determination. The parties in the interim are ordered to file and exchange pleadings. So while the appeal succeeds, the court orders that the case file be transmitted back to the lower court, to the chief judge for reassignment to another judge for trial. Now, my Lord Sankey was the presiding justice at the hearing of this appeal. She sent in her contribution to the lead judgment, but if you just permit me, I will just take the conclusion of her contribution, and it says, well, it says that I had a preview of the lead judgment just delivered by my learned brother. I agree with my Lord's analysis and conclusions on the issues in the appeal. Went further to elucidate on the issue of undefended list, and finally came up by saying that it is for this reason, and the reasons so ably set down in the lead judgment, that I also find the merit in the appeal. I abide by the consequential orders therein. My Lord Awotoye was also in the panel, and his contribution is simply that he had the privilege of reading the draft of the judgment just delivered. I agree entirely with the reasoning and conclusion therein. I have nothing new to add. I abide by the consequential orders made. So this is the judgment of the court in this appeal. There is merit in the appeal, and the order of the court is that the case file be transmitted back to the lower court for reassignment to another judge, for same to be heard and determined on merit. Thank you. Registrar.
My Lord, we're very grateful for this judgment and also for.
Yes, we are listening.
Francis, people.
There's breaking transmission. Well, I don't know if you can hear me. I think we have come to the end. Yes.
Yes, my Lord.
Yes, my Lord.
I think we're very grateful for what my Lord did from the President of Court of Appeal, who came here to judge and helped us to extract of the appeals here in Jos. We also pray that God will continue to grant my Lord expeditiously. Thank you very much, my Lord.
Thank you so much. Although I didn't even get up to 80% of what you said, but I know that you wish me well. And I also wish you well in return. Enjoy the Salah. And the court has come to the end of the day's proceedings. Thank you, Registrar and other staff that turned up today for this. The court will rise.
Court.